Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Coming to you from Washington's nicest indoor shooting facility. Of course, that's Security Gun Club right here in Woodinville, Washington. Hey, there's been a lot of whirlwind events going on, a lot of events related to gun laws and things like that, including the horrible incident in Maine. There's been some other big cases, and there was a huge case that kind of just slipped under the radar, didn't get a lot of coverage. I've had a chance to geek out on it. Not only is it huge, but I think it actually might give us a little sneak peek at what the United States Supreme Court will do with a case that already is on the docket and another case that's likely going to end up on their docket. So today, let's spend a few minutes. Let's get you educated about this case, and let's talk about the huge case that no one is talking about. Okay, so here's the case we're talking about today. It's a case called United States v. Alston. It is filed in the Eastern District of North Carolina in the United States District Court. The ruling by the Honorable Louise Flanagan, a George W. Bush appointee, had to deal with two issues, one of which is going to be challenged next month at the United States Supreme Court, in part in the matter of United States v. Rahimi. The other issue, the United States has asked for certiorari to have it reviewed by the United States Supreme Court in the matter of United States v. Daniels, which is a challenge to whether or not cannabis users should be barred completely from ever owning or possessing a firearm. Now, this case actually challenges two separate sections of United States Code. The first one is 18 U.S.C. section 922 subsection N, which makes it unlawful for any person to be in possession of a firearm if they are currently under indictment, an accusation supported by probable cause for an offense which exceeds at least 1 year incarceration. The other challenge, and we have talked about this challenge on a few other videos, is to 18 U.S.C. section 922 G3, which of course is the prohibition on those who use controlled substances, in this instance cannabis, providing that if you are a user of those substances, you are absolutely barred at all times in your life from possessing a firearm. Now, of the two sections that were challenged here, Judge Flanagan has ruled that one of them is in fact unconstitutional. Let's talk about the one that the judge found was constitutional. This is 18 U.S.C. section 922 subsection N. This is a prohibition against people possessing firearms who are currently under indictment for offenses that they could be jailed for more than a year. It is very similar to one of the many issues before the United States Supreme Court next month in the matter of United States v. Rahimi. The court specifically ruled, defendant argues that the government's authority to deprive those under felony indictment of their liberty pending trial is not an appropriate historical analog for modern restrictions on those individuals' receipt of firearms. The court disagrees. The court went through a brief historical analysis, but determining that these individuals were by society deemed to be dangerous, the court then ruled, the same document thus provides historical support for the individual's rights to bear arms and the government's ability to detain that individual, suspending temporarily any right to armament upon probable cause that the individual has committed a felony. Where section 922N restricts the right of those under felony indictment to bear arms to a lesser degree than restrictions present at the founding, the government has carried its burden to show that the provision is consistent with the nation's historical tradition of firearms regulations. So that is really, really important because, again, and we've talked about it on this video and we've talked about it a little bit on this video here too, there is a historical tradition going way back to even before we declared our independence of restricting firearms from individuals that society deems as dangerous. Now, when it comes to section 922 G3, however, which is the prohibition on cannabis users, and that was the drug that was at issue in this particular case, the court has actually found that no, that law as applied is unconstitutional. Now, one of the many things that the government always argues on these controlled substances cases is, hey, the Second Amendment only protects lawful individuals, and anyone using a controlled substance is, of course, not a lawful individual, and therefore the Second Amendment does not even cover them. The court wasn't particularly persuaded, and in fact ruled, where the Supreme Court has suggested strongly that all Americans enjoy some degree of Second Amendment protection, and where the Fourth Circuit has never held users of illicit drugs to be excluded from that protection, the court adopts the magistrate's judge's determination that for purposes of this 922G3 charge, defendant remains a person who possesses Second Amendment rights. Now, the government did offer 3 attempts at historical analogs to uphold this law. The first is, of course, the tradition of banning firearms from those that are mentally ill. The problem is they cannot make a causal connection between those that are occasional cannabis users and those that are mentally ill. Of course, the second one, and this is the one we most commonly see, is a long, long tradition of banning those who are intoxicated from possessing firearms. And there is a rich tradition, even predating the Declaration of Independence, of banning possession of firearms from people who are actually intoxicated at that time. But as the court points out, what you're asking to do here is you're asking to ban at all times because there's a possibility that at one point in their life they may be intoxicated. As the court put it, the government's reference to 19th century laws limiting the intoxicated from using firearms similarly falls short, where those laws apply only to actually intoxicated persons, not persons likely so to become. And then finally, the United States pulled out another one of its old playbooks, which is let's just rely on all of the laws that were originally rooted in racism to show that, hey, listen, anytime we deem somebody to be dangerous, we get to take their firearm rights. The court was not really particularly persuaded, as they found. The why of these laws, however, do not neatly map onto the purpose of Section 922G3. Colonial and early American laws preventing dangerous individuals from owning guns reflected a fear that those guns might be used to overthrow the government, whereas Section 922G3 simply seeks to promote public safety. So at the end of the day, the judges ruled that 18 U.S.C. Section 922N, that is the prohibition against possessing firearms if you're currently under indictment for an offense that carries more than a year, is in fact constitutional. However, and this is now multiple rulings that we have gotten on multiple courts, and this is similar to what the United States is asking the United States Supreme Court to review in United States v. Daniels, and that is that 18 U.S.C. Section 922G3, the prohibition on controlled substance users from possessing firearms at all times, has yet again been found unconstitutional. The case, once again, is United States v. Alston. We will link up down below in the description box the opinion so you can geek out on it for yourself. I think this is a huge case because I do think that this kind of telegraphs a little bit about what a slightly conservative-leaning court might do with the Rahimi case, as well as what they might do should they accept review on United States v. Daniels. Listen, if you have any more questions about this or anything else related to what's left of our Second Amendment rights, you guys should know how to get a hold of Washington gun law by now. If you don't, that's okay. That information is right down there in the description box. In the meantime, let's everyone remember that part of being the lawful and responsible gun owner, like we talk about all the time here, is to know what the law is in every situation, how it applies to you in any instance that you may find yourself. Until next time, thanks for watching. And stay safe.